Greetings, my name is Luca Castellani.
And my name is Karina Sibilska, and we work at the UNCITRAL Secretariat.
We would like to discuss today the interaction between the CISG and the Hague Principles on Choice of Law, with particular regard to the principle of party autonomy. The CISG, or United Nations Convention on Contracts for the International Sale of Goods, is a treaty that has been concluded in 1980 and that is considered the most successful uniform commercial law treaty in the world, having achieved almost 100 state parties. It sets forth the rights and obligations of the seller and the buyer and a number of other issues related to international sale of goods. Contract for international sale of goods is the backbone of international trade, as it is the most frequent one.
The Hague Principles on Choice of Law in International Commercial Contracts, known as the Hague Principles, were adopted on the 19th of March in 2015 by the members of the HCCH and aim at reinforcing the principle of party autonomy and strengthening legal certainty and predictability in international commercial transactions. The Hague Principles therefore provide a modern international standard for countries engaged in reforming choice of law rules in the area of international commercial contracts. So, what is party autonomy?
Yes, indeed. The CSG and the Hague Principles are different uniform commercial law texts. The CSG is a treaty. As such, it is binding on the parties to the contract, although of course both parties may vary its provision or opt out, as we will see later. While the principles are a piece of soft law, if you so wish, although they can be used to inspire domestic law reform. But they have one element in common, particularly prominent for our discussion today, which is they both promote this principle of party autonomy. Now the question is, what is party autonomy? Party autonomy is the principle underpinning commercial law and contract law that says that the parties to the contract, they are free to choose the law applicable to their commercial dealings, and they're also free to determine the clauses of the contract and vary the provisions of the applicable law. Why is this done? Because this allows to achieve two main goals of an enabling legal environment: predictability and flexibility. We have predictability on which law applies and which provisions will apply, because the parties have agreed on those provisions. They have negotiated them, ideally. And we have flexibility because we give to the parties the possibility to choose which national law or other law will apply and to change that law to tailor the contract to their needs.
But with that being said, there are limitations to party autonomy, is that correct?
There are limitations to party autonomy. Of course, party autonomy finds a limit in another fundamental notion, which is public policy. Or if you wish, party autonomy in French is l'autonomie de la volonté, and public policy is known as ordre public. Public policy is exactly a reference to those rules in national law that the parties may not change because they have mandatory application. Now the issue is that some of them are common to many or to all legal systems, but some of them are very specific to some legal systems. So it's not so easy to predict in advance which specific mandatory rule will be relevant for that transaction and may actually invalidate that transaction, because that's the sanction for violating public policy.
So then what would you say the relationship is between uniform commercial law and private international law?
Yes, indeed. We are looking here at two very similar but slightly different notions. Private international law has to do with finding which law applies to a certain relationship, or even giving to the parties the possibility to choose that law, as we said before. We say sometimes a uniform commercial law reduces or somehow limits the scope of private international law, but I don't think that's correct. I think that it's more correct to say that there is a full complementarity. For instance, if we look at the CSG and the Hague Principles, in the CSG we have rules on the scope of application. We have Article 1. Article 1.1a, of course, says CSG applies when all parties to the contract have their place of business in a contracting state. But then Article 1.1b says, and it also applies when the rules of private international law point at the law of a contracting state. So here we have a reference to rules of private international law, which must exist. And then there is a further case, which is the case that we are discussing now, which is implicit in the CSG, and that is the CSG applies when the parties choose it as the applicable law. And here we have some options, because normally this would happen through the choice of the law of a contracting state. And normally we consider that the law of the contracting state, of course, includes the CSG, and that's the absolutely prevailing view, and that's how it should be, because the CSG is a treaty that as such is in force in that state. And there should be an explicit decision to exclude the application of the CSG if the parties don't want to do that, which is of course legitimate under the CSG, but has to be explicit.
So in practice, how do the Hague Principles facilitate the application of the CISG?
They facilitate it in two ways. First of all, they want to expand the operation of party autonomy to all jurisdictions. This is really important because party autonomy is very well established in certain legal systems, but it's not so established in our legal systems, in particular in developing countries. This is due to lack of capacity, also limited opportunities to deal with these type of issues. And that's where the Hague Principles really innovate. Even in the countries where the principle of party autonomy is very well established, usually it is understood as referring only to national law. So there must be a reference to a specific jurisdiction. But the Hague Principles open the door to the adoption of a body of non-state law, or a national law. That means that this body, there are cases where there is a cross-border trade, and the parties really, they don't want to refer to any specific national law, and so this body is removed from any specific jurisdiction. In practice, for instance, I can have a contract for international sale of goods, and I can say I will apply the CSG as supplemented by the Convention on the Limitation Period in International Sale of Goods, and as supplemented by the UNCITRAL Principles on International Commercial Contracts. But these are purely uniform commercial law texts, and so far I didn't make any reference, and I'm not making any reference to any particular national jurisdiction. So that's really a major contribution of the Hague Principles in opening the door to that level of abstraction from national law.
All right, so you've given us a few benefits, but are there instances where the interaction is a little more problematic?
Well, problematic is a strong word. Let's say where there's opportunities for further development. For instance, the commentary to the Hague Principles discusses a specific matter, which is the so-called battle of the forms. This happens when the two parties to the contract, they make reference to their own terms and conditions, and these terms and conditions are incompatible. In particular, in this case, they could be incompatible with respect to the choice of applicable law. And the issue comes out of actually business practice, because business people, they wanted to execute the contract because they look at the economic value, and they are not interested in, if you wish, the theory of contract negotiation or perfect contract formation. And then if there is an issue, if there is a dispute, or even a discussion on what's the appropriate performance of the contract, then of course they need to find out what's the applicable law. And in that case, you don't have an agreement on the applicable law. The CSG has a rule which is already quite advanced, but it does not give the final operational guidance, because there are different options, so-called first shot, last shot, knockout. These are different ways of dealing with the matter. The CSG doesn't do so also because the CSG is always open to flexibility, to adaptation of its provisions to the actual circumstances of the contract. And the commentary illustrates several of these options in detail and provides guidance on how to implement the various options. Of course, it's not authoritative, because it is an illustration of certain views, but it is yet a useful contribution to the development and the consolidation of a uniform trend in the interpretation of this provision of the CSG.
So then what is the CISG doing for party autonomy?
The CSG actually does the most important thing for party autonomy in those jurisdictions that do not have a strong understanding or a strong familiarity with party autonomy. Unlike other treaties, CISG Article 6 says parties to the contract may vary any provision except the one on the written form, or may even opt out of this convention. Now, for those who don't know well or not familiar with contract law or commercial law, this is very exceptional, because usually treaties are mandatory application. But the CSG is an enabling treaty, commercial law. And as such, it gives an option to the parties, exactly because party autonomy is the prevailing principle in the CSG. The CSG says, you have the options to choose another law, because this suits you better. So you can go that way. But if you don't, for whatever reason, and let's not forget that in many cases, especially small and medium-sized enterprises, especially traders in developing countries, don't have the resource to have a full contract negotiation with qualified legal advice. Well, if you don't make that decision, then here comes the CSG to help you with its own neutral, comprehensive, balanced set of rules, and helps you in understanding how to perform your contract in an equitable manner. So yes, the CSG is first and maybe one of the most underrated contributions, but actually most important, is to promote and strengthen the operation of party autonomy also in those jurisdictions that don't know well that principle.
So then going back on the notion of choice, does the dispute resolution method make a difference with respect to the application of party autonomy? So for example, would litigation within a state court then differ from arbitration?
Well, traditionally, we like to think that arbitration is particularly tailored for international trade because of its own nature, because of the fact that arbitrators are selected in light of their knowledge and expertise. They're already familiar with these texts and notions. And in fact, arbitration and CSG make a great match. At the same time, it's true that the state judge, especially when less familiar with these issues, may have a broad understanding of the notion of public policy, including may misunderstand public policy as protection of national economic interest, which of course is detrimental to international trade, because what international trade wants to see is fairness and predictability. It does not want to see decisions that are based on domestic interests. And And so this is one way of looking at it traditionally, but I would like to say there are also other factors. There's a lot of judges who are perfectly familiar with these issues, and they know very well party autonomy. There's an increasing trend in setting up international commercial courts, which are of course only fully qualified in dealing with this. And on the other hand, in arbitration, arbitrators may have a broad notion of party autonomy and maybe a narrow notion of public policy, but public policy comes back at the time of enforcement of the award. And the Convention on the Recognition and Enforcement of Foreign Arbitral Awards does have a public policy notion, but some countries may then interpret again this public policy in a little bit broader manner.
Moving forward, how do you see the interaction of the CISG and the Hague Principles in promoting party autonomy?
Well, as I said before, these are really good match in the two texts. And I would add to that that they are a good match because they come from institutions that have done a lot for a long time to promote uniform commercial law, and who wanted to promote the interest of the private sector and the traders as much as possible. To me, party autonomy really reflects the prevailing interests of private parties, of the business people. And in a way, I like to think that it comes to us from the medieval times, from the community of merchants, from the lex mercatoria, these kind of notions. While public policy, of course, is related to the notion of state, state should regulate in the public interest, of course, that's absolutely understandable. But it is a notion that comes up with the notion itself of nation state, and it is a notion that can become detrimental to trade if it becomes over-regulation.
So to conclude, do you have a practical recommendation or a solution on how this interaction can be made more effective?
Well, I don't know about the solution, but I do have a practical recommendation based on my experience, especially in delivering technical assistance to developing countries. I really believe it is important to build the capacity in both countries. I think that this capacity gap has an impact on contract management, on the conclusion of the contracts, on performance of the contracts, and also on dispute resolution. But I would say it's really important, first and foremost, to have enough knowledge that it is possible to negotiate fair contracts and also to perform them fairly. This is an issue that is sometimes taken into account by the international community, the donors, in the framework of private sector development and with reference to establishing an enabling legal environment for trade. We are trying, of course, also to prepare some tools, and I would like here to recall the recent guide that was prepared together by UNCITRAL, the Hague Conference on Private International Law, and UNCITRAL on uniform commercial contracts with a focus on sale, which is available in the 6 official languages of the United Nations at no cost. And in that guide, there is actually also a detailed discussion of party autonomy and of the interaction between CSG and the Hague Principles. So I believe that our audience will find additional information on what we were discussing today in that guide, and would have additional considerations and additional ideas to further investigate the matter. But really, I think that this issue and overall the promotion of uniform commercial law should become more prominent on the international law agenda and the agenda of the donors, because of the direct correlation between the adoption of these texts, economic development, and social stability, which is, of course, a major goal for all of us.
Thank you very much.
Thank you.